Yes, good evening to everybody. The All India Bar Examination aspirants, the cohort 17-2022. Yes, can anyone unmute and read what I posted on the screen? Can anyone unmute and read what I posted on the screen?
Administrative multiple choice questions. Dr. Mohammed Saheb Hussain.
There is no Saheb, there is a S. Hussain is there. Okay, doesn't matter. Doesn't matter. Okay, without wasting the time, let me come to the point. All India Bar Examination, 17th Court, 2022, Administrative Law, multiple choice question. Yes. Now, read the first question. Anyone can unmute and read the first question?
First question, administrative law is defined as dash. Number one, the body of rules governing administrative agencies. Number two, the body of law governed administrative agencies. Number three, the body of law governing administrative agency. Fourth, the body of law governing administrative agencies.
Which option is correct among the four? 1, 2, 3, 4. I quote, the body of rule governing the administrative agency, I unquote. Second option, I quote, the body of law governed administrative agency, I unquote. Third, I quote, the body of law governing administrative agency, I unquote. Fourth, I quote, the body of law governing administrative agency, I unquote. Even though it is wrong, doesn't matter, make a hunch. Sir, we are tafuta. We are searching in the smartphone. Don't do like that. If you do like that, you are deceiving yourself. What is the right answer? Anyone? Answer is the body of law governing the administrative agency. That is the fourth. The fourth option is the correct option. Administrative law is defined as the body of law governing the administrative agencies. The fourth option is the correct answer for the first question. The second question, who enacts statute? Number one, legislative. Number two, parliament. Number three, state. Number four, all of them.
I think all of them, sir. All of them.
It is a easy question. That's why everybody gave the answer. I want to twist it actually. Actually, I would like to say something. Peoples of the state, but peoples of the state also responsible for the enacting the law. It is there. So I did not write that option. I said, okay, let me make it easy. At least say whether the people could understand it or not, whether they are wise enough or not, whether they are following my technique or not, whether following my logic or not. I would like to see it. That's why I put that one. Okay, third question. Administrative agencies dash regulations under the authority granted to them by either constitutional provisions or statutes. Find out the correct sequence. Number one, adapt, repeal, amend. Number two, adapt, amend, repeal. Number three, adapt, amend and repeal. Four, amend, adapt and repeal.
I think third one, sir. Adopt, amend, and repeal. I think.
The right answer is third one. You are right. Adapt, amend, and repeal. That is the right sequence. You are right. Fourth question. Yes, anyone can unmute and read?
Fourth question. The administrative law judge renders a decision called dash. One is not connected or odd man out or false one. Number one, an administrative order. Two, which may not be reviewed. Three, by a higher level within the agency. Four, or by a court.
I think which may not be reviewed.
Yes, yes. Not it should not be there. This is the, because I put the not to give a confusion to you. So an administrative order which may be reviewed by a higher level within the agency or by a court. So the right answer for the odd man out for the fourth question is second option. Is it clear? Say yes.
Yes.
Very good, very good. The fifth question. Administrative agencies are created by dash. One is false and three are correct. Number one, government to administer particular legislation. Two, such as the Social Security Act. Three, Workman Compensation Act. Fourth, Fatal Accident Act. One
I
is
think
not
the
correct. The three
first
of
one,
them is
sir.
correct. Yes?
First one.
No, first one is correct answer.
Okay. I'm not very sure, sir.
First one is the correct answer. By a government to administer a particular legislation, such as the Social Security Act, second, third, Workman Compensation Act, fourth, Fatal Accident Act. One is not related to it. A bit tough one this is, unless until you have the very background of it. Yes, the right answer is Fatal Accident Act is not there, but Workman's Compensation Act is there, and Social Security Act is there, and the government to administer the particular legislation is there. So fourth is the answer for the fifth question, which is not connected. Okay? Say yes. Can I proceed? Say yes. Can I proceed? Say yes.
Yes, sir.
Why you are taking so much time to give the answer? Sixth question. The main purpose of administrative law consists of, number one, I think I have to forgotten to write there, which is not related to it. False. One is false. The main purpose of administrative law consists of, number one, ensuring the accountability for the administrative agency. Number two, by providing for the judicial review of agency actions. Number three, this body of law motivates the power of the exclusive branch. And the fourth one is provide transparency to the public. I think one is not connected to it. One is not connected to it. Means one is false. Among the
Judicial
four.
review is not connected, sir. I think B, second one, by providing judicial review of agency action.
See, feedback I have given. Check the feedback. This body of law curbs, I say motivates. Did you get my point here? See, this is, I wrote motivate, but actually it is curbs, not motivate. So the right answer is
Third one.
third one.
Fourth,
For
sir.
the sixth question. So that is the next question. Anyone can unmute and read?
Administrative agencies can be categorized into three.
Okay.
Indicate correct one. The legislative, the executive, and judiciary. The legislative, executive, the judiciary. Executive, legislation, and the judiciary. The legislation, the executive, and the judiciary.
Correct sequence. Among the four, only one is there.
I think third one, sir. Executive, legislation, and no.
Legislative, executive, judiciary.
And judiciary. Second one, sir.
One, sir, one number.
Check once again.
Legislative, sir.
See,
Legislative, judicial, and executive.
number one is correct. Number four is correct. See. Are you following me? Number one is correct and number four is correct. I made the mistake here. I actually want to remove something there. I did not remove it. So the answer is
1 and 4.
1 and 4. Actually, I want to change something in the 1, but I could not change it, I believe. I thought I changed it, but doesn't matter. At least you know now the correct sequence. Okay, next the fourth question. Eighth question, because my time is so much today, shortage of time mine. So I could not remember it because I taught here the Moshi, the legal research for 2 hours. Okay, administrative law deals with dash. Which one is false? Number 1, the authority's power. Number 2, the manner in which these powers are exercised. Number 3, and the remedies accessible to the aggrieved individuals. Number 4, when these authorities use these powers. Actually, I've shown the feedback. I don't know how many people could remember it. Okay, I mean the 4 options, which is the correct option. Parshuram,
Sir.
from your side, I'm getting the sound. When you want to speak, you can mute it, unmute it. When you don't want to speak, you can mute it.
The third one, sir. The remedies accessible to the aggrieved individuals.
See, when these authorities abuse these powers, but what I wrote, these authorities use the powers. Which is the right answer? I gave the feedback. When these authorities abuse the powers, these powers. But I wrote that the 4th option is when these authorities use these powers. So which is the right answer?
4th, sir.
4th one is the answer for the 8th question. Next, question number 9. Read. Question number 9, read. Question number 9, read.
9th question. Administrative law is a part of a dash. Evidence law, state law, constitutional law, central law. Constitutional law, sir, answer.
Answer is the constitutional law. 3rd is the answer. Next question. That is the 10th question. Anyone can unmute and read 10th question.
10th question, sir. All administrative law concerns are also dash concerns. Administrative law, option 1, option 2, constitutional law, 3, tort law, 4, civil law. Sir, option 1, sir.
No.
All administrative.
Option 2.
Answer 2. All administrative law concerns are also constitutional law concern. So, administrative law is a part of the constitutional law. Next question is 11th question. I will read the 11th question. The primary aim of the study of administrative law is to dash how it is possible to keep these administrative authorities within their limits so that discretionary powers cannot be transferred into the arbitrary powers. Number 1, ravel. Number 2, unravel. Number 3, tie. Number 4, untie. In this dash, which is the appropriate word?
Unravel, number 2.
Unravel is the appropriate word. Unravel is the appropriate word. Okay, now let us see this a bit. I jumbled it. The role of administrative law is to dash which one is being correct. Number A, unlimited government agencies. B, power. And C, to unkeep administrative authorities. D, in check. Number 1 option, A and C. Number 2, A and C. 3, B and C. 4, B and D.
Sir, 4, sir, B and D.
B and D is the right answer. There is no unlimited. There is a limited government agencies and there is no unkeep. There is a to upkeep. That is to keep administrative authorities. That is the wording should be there. In the feedback here, you can see the role of administrative law is to limit the government agency powers and to keep administrative authorities in check. So that would be the answer. In the sense, for the question 12th, the answer is 4. And question number 13, yes, anyone? No, I will read it. Which one is the correct statement? Statement is correct. Number 1, administrative act should act as the proper law governing administrative action. Number 2, administrative law should do as the proper law governing administrative actions. Number 3, administrative law should act as a proper law governing administrative actions. Number 4, administrative law should act as the improper law governing the administrative action. There are
Number 3.
number 3 is the right answer. Administrative law should act as the proper law governing the administrative action. That is the very correct answer. Other two, I made the mistakes here and there, and that's why they are the false. Yes, anyone can unmute and read the question number 14. Question number 14.
Question number 4. Not administrative authorities in India. Option 1, IAS, Indian Administrative Service. Option 2, Indian Police Service. Option 3, Indian Foreign Service. And option 4, Indian Air Force. Sir,
Number 4, sir.
Indian Air Force.
No.
1, sir.
4.
No.
1, sir.
No. Today everybody failed. I got the point. What is the right answer?
3, sir.
3. There is no Indian Foreign Service is there in the administrative authorities. I saw Indian Administrative Service there, Indian Police Service is there, Indian Air Force is there, Indian Navy is there, Ministry of MSME is there, Ministry of Micro is there, Small and Medium Enterprises is there, Indian Military is there, BSF is there, and so on. Department of Finance is there, Home Ministry is there, and these are all come under the administrative authorities in India.
Sir. IFA is not there, but IFS is there. Indian Foreign Service is there.
No, IS is there because I checked it there. From there only I found it.
Example, here what you have written, sir? Number 3, IFA you have written. Abbreviation.
IFS, IFS, Indian Foreign Service, IFS.
IFS is there, sir. You know the Maneka Gandhi case, na? That was the case by IFS only.
Yes, IFS, because I made a mistake. Indian Foreign Service, I know.
Passport officers are IFS people only, sir. Passport you are getting, that issuing authority is Indian Foreign Service Authority.
I will show you the answer, total answer I will show you, because I tapped from there. This Parshuram, when you want to speak, you at the time you can unmute it. When you don't want to speak, at the time you mute it, because I am getting the resound.
Okay, sir. Okay, sir.
Yes. This is last test fire. And oh, this is different is opened. No, not this one, not this file. I think this file only that I made it.
The blocks may be sometimes false, sir, sometimes wrong. Students only writing them.
Is it? But anyway, that let us see that. Okay, subject to the correction. Yeah, subject to the correction that we'll make it out here. But time being, we'll proceed further. Okay? Shall I proceed?
Passport office, sir.
Shall I proceed?
Passport office. Yes, sir. Yes, sir.
Yes. The 14th question, let me put it in abeyance, time being. And now proceed to the 15th question. The 15th question is, this doctrine is fine. Which doctrine? Let us see that. For example, creativity of the judiciary, the origin of the doctrine may be linked to the constitution, which upholds the arbitrariness insist of fairness of administrative transactions. So, it is a doctrine of possibility. And that is connected to the Article 13, Article 14, Article 19(1)(a), Article 21.
Article 13, sir.
No, it is 14.
No.
You know what is Article 13? It is about law. Article 12, it is the state. Article 14?
Yeah, Article 12 is the state. Article 13 is
12 is the
Equality
state.
before law.
12 is the state.
12 is the state, sir.
13 what is law? Law.
13 is the law. What I told you the correct. And 14th is
14 is
Equality before law.
right to equality.
the
Equality
right to
before law.
equality doctrine. Impartiality would be there. So the first reference to the doctrine of legitimate expectation is to be found in the case of number 1, State of Madras versus Achyutan Pillai. Number 2, State of Bihar versus T.N. Ganguly and others. Number 3, State of Kerala versus K.G. Madhavan Pillai. Number 4, Indian National Congress versus Institute of Social Welfare and others. Doctrine of legitimate expectation is to be found in the case of.
Number 3 yoga, sir.
Yes, it's the number 3, State of Kerala versus K.G. Madhavan Pillai. In that case, now the doctrine is used over there. Yes, that is about the 15th question and 16th question is over. Now let us move to the 17th question. And here the 17th question. Anyone can unmute and read? 17th question. Yes. 17th question.
17th question. If the government has made a scheme to provide drinking water in villages in a certain area, but later changed it to exclude certain villages from the scheme's purview, then what is violated in such a case is the people's legitimate expectation in the dash. Option 1, cutout of village. Option 2, inclusive village. Option 3, included village. Option 4, excluded village. Sir, question.
4.
Yes.
Number 4.
Number 4. It is excluded village because it is not taken into the purview. So next question, I will read it. Question number 18. Yes, 18 question number. In the case of dash, SLP, supplementary question. What is SLP? What is SLP?
Special leave
petition.
petition.
Special
136.
leave petition. Okay. Within parenthesis, SLP Civil 1993, the Supreme Court noted inter alia that while it dealt with the validity of the legislation infringing the fundamental freedom listed in the Article 19(1) of the Constitution of India, it was repeatedly questioned whether the restrictions imposed by the legislation were disproportionate to the situation or not the least restrictive choices. It is observed in the number 1, Ram Kumar versus Union of India. Number 2, Om Prakash versus Union of India. Number 3, Om Shanti versus Union of India. Number 4, Om Kumar versus Union of India.
Om Prakash versus Union of India.
Wrong. Next option. Next option. It is the Om Kumar versus Union of India. That is the 4th option is the right answer for the 18th question. Now can anyone unmute and read 19th question? 19th question. Read. Unmute and read. 19th question. Read.
Dash was one of the earliest decisions on judicial review in administrative law. Options: Ranjit Thakur versus Union of India, Ranjit Udeshi versus State of Bombay, Ranjit Thakur versus State of Bombay, Ranjit Thakur versus State of Bombay.
I repeated
Number
it,
2,
3rd
sir.
and 4.
Number 2, sir.
I
Udeshi.
repeated 3rd and 4. But the number 2, Ranjit Udeshi versus State of Bombay is a ladies shortlier lovers. That book is banned. That is Ranjit Udeshi case law in the IPC.
Okay, sir.
Here, answer is both 3 and 4. Is it? Appa Anna. Answer is Ranjit Thakur versus Union of India. Number 1, Ranjit Thakur versus Union of India is the right answer for the 19th question. Was one of the earliest decision on the judicial review in administrative law. Oh, somebody is speaking. Please mute it. I could hear your household talks.
Yes.
Please, in Parshuram, you mute it. When you want to speak, you can unmute it. Then now you mute because I saw your icon is. Yeah, now it's okay. Yes. 20th question. Can anyone unmute and read? When I say unmute and read, you don't read.
Many judgments have been made which clarify the doctrine of proportionality in dash of the Indian Constitution. Options: Article 12 and 19, Article 13 and 19, Article 14 and 19, Article 15 and 19.
Sir, option 3, sir.
Option 3 is the right. Many judgments have been made clarify the doctrine of the proportionality in dash of the Constitution, means Article 14 and Article 19. That is the 20th question. Right answer is Article 14 and 19 is the answer. Next, 21st, 21. Anyone can unmute and read. Yes. 21. Unmute and read. Parshuram, why you don't read it now? You are unmuted, but you are not reading.
21st question. In Europe, in the 19th century, the doctrine of proportionality was developed and originated in dash. Prussia, option 1, option 2, Russia, option 3, Botswana, and option 4, The Hague. Sir, it's option 4, sir.
No. Prussia, Prussia. Number 1. In the Europe, in the 19th century, the doctrine of proportionality was developed and originated in Prussia, Prussia. That's the first option for the 21st question. Next question, 22. Yes. Can anyone know? I will read it because you take more of time. Proportionality means dash. One of these is false statement. Number 1, that the administrative action should not be more elastic than it should be to achieve the desired outcome. That the legal action should not be more drastic than it should be to achieve the desired outcome. The administrative action should not be more drastic than it should be to achieve the desired outcome. That the administrative action should be more drastic than it should be to achieve the desired outcome. Which one is a false statement? Which one is the false statement? Proportionality means one of them is false.
Option 1, sir.
4.
4, sir. 4. 4.
4.
Check again.
Number 4, sir.
It is 3.
Yes, sir. 4 only. So you are telling false one.
Yes, I told the false one.
It should be more drastic, you are telling.
అవునండి నెంబర్ 3 ఫాల్స్ వన్ ఇక్కడ.
Sir, number 3 is right one, sir. 4 is false.
Are you sure?
Because administrative action should not be more drastic. That means in one case, one employee was absent on one day, he was dismissed from service.
Okay.
So then the court told the punishment should be proportionate. You can cut one increment or some penalty on him, but you cannot remove him from the service totally. That is the doctrine of proportionality.
Okay.
If somebody slaps us, we cannot stab him. We can also slap him or beat him for more 2-3 times extra, but we cannot stab him and kill him. That is the doctrine of proportionality. Punishment should be proportionate to the action.
Yeah, the fact quality being the proper balance in relation to the size and quantity and degree and severity. In all the aspects, the severity would be there. Now let us check it, what exactly they wrote. So that administrative action should not be more drastic. Then it should be achieve the desired outcome. It is more drastic. Yes, you are right. The fourth one is the right. It should not be more drastic because it should be equal to the proportion to it. So that is the right. Yes, not the third question the right. That the fourth question is the right answer. So the administrative action should be more drastic. Then it should be not more drastic, son. It should be drastic, not more drastic. Not more drastic, drastic. Yes, fourth one is the right answer.
You are asking false. That's
Yeah, I am asking false. Yeah, I am asking false. At the time, when I am asking false, yes, yeah, not drastic. No, because here it should not be drastic, more drastic, and should not be more drastic, and should not be more drastic. In all the places, it should not be more drastic. Hence, the three are right, and the fourth one is wrong. Is it correct? The fourth one is wrong. Hence, the answer is fourth one. Because in all there should not be there. So here I not removed. Are you following me?
Yes, sir.
In the three places should not be there. You observe it. But in one place is not there. That means the fourth one is the right answer for that one. Proportionality means. Yes, I appreciate. Yes, this is a long one. You cannot read it. I read it. The next question, 23rd question. The doctrine is not, I said not, please note the point. The doctrine is not applied in the following situation. That is, one is odd man out. Means all four are relevant, but one is odd man out. Number one, where an administrative action invades the fundamental rights, the court scrutinizes the administrative action strictly and address the issue of the correctness of the authority's choices. The court would also balance adverse effect on the rights and objects which are sought to be achieved. That is number one. Number two, where there is a question of quantity of the punishment imposed by the administrative authority, the court would not undertake the strict scrutiny. Court will follow the principle that while the quantum of the punishment is within the administrative authority's jurisdiction, arbitrariness must be avoided. Number third, while reviewing the administrative action on the basis of the proportionality, judges usually examine the two things. Number A, whether the relative merits of the distinct objective or the interest have been adequately weighed or unbalanced. Number B, whether the action under the review was exclusively restrictive or an unnecessary burden imposed in the circumstances. The fourth one is where there is a question of the quantity of the punishment imposed by the administrative authority, the court undertake the strict scrutiny. Courts follow the principle that the quantum of the punishment is within the administrative authority's jurisdiction. Arbitration must be avoided. So I made the number 1, number 2, number 3, number 4. Which one is odd man out? Not relevant. It is a tough question because we do have the broad knowledge on it so that we can make it out.
Number 2, sir.
Here feedback I have given. See, where there is a question of the quantity.
2 is the odd one. Number 2.
Here I have given where there is a question of quantity of the punishment imposed by the administrative authority, the court would not undertake. But here I wrote would undertake. In the fourth one here, the cursor is there. I wrote would undertake. But the right answer is?
Now, number 2.
No. It's 4.
Odd one is number 2, sir. You see number 2.
No, in this connection you are fail. In this case you are fail. I am the one winner.
Okay, sir. Number 2 you see, sir. Number 2.
It is the fourth one because I changed the one. I took as it is.
You also have written same thing. Court would not undertake is written in number 2. What you have written?
Yeah, court would not undertake strictly. Yes, number 2. That's the same thing. Where there is a question of quantity of.
Yes, sir. Number 2 and feedback are matching, sir.
There is a question of the quantity of quantum. I means number 2 and number 4 is the same.
No, sir. 4 not removed. 4 14 second not is there.
Okay.
So that is odd one out.
But
second
as
is
for my knowledge goes over there, because I pasted and copied from the where there is a question of quantity of the punishment. And there also where the question of quantity of punishment imposed by the administrative authority, the court went, yes, number 2 is the right answer. You are right.
Yes, sir.
Yeah, you
Yes,
are
sir.
right. Because I copied from this one. I copied from this
Yes,
one,
sir.
I pasted over
Because
here.
yours are very complicated and sir questions are sometimes confusing, even the primer also.
Yes. That is true.
Very lengthy questions.
Yes, it is a lengthy question. Unless until that you have the grip over the administrative law, you cannot make it out. Okay.
Yes, sir.
By chance you can shoot it. And sometimes because you use the logic, when you use the logic and reasoning, at
Yes,
the time
sir.
you can shoot the correct one.
Yes, sir. Yes, sir.
So that is another way of dealing with
Sometimes I do like that, sir.
Yeah, because you should use the logic. And we can say that, this may not be right answer. We can eliminate it in the beginning only. In the beginning only we can eliminate it. Then we'll read the another one. When we read the another one, our logic will say, yes, it is the correct answer. And we read the another one, then we know that, oh, this is not changed and this is changed. And hence we can come to the conclusion. But only the thing is, your mind should be prepared in that way. Means the software should be developed in your mind in such a way you can easily remove the things by reading only part of it. So that the quickness shows your sharpness of the brain and where you can reach the target within a stipulated time and you can complete it also. That is a very much important factor. In the competitive examination, time is the important factor because you know the answer. But when you read that 2 times only, you could understand the answer. But 2 times no. Half of the question when you read it, you are in a position to give the answer. Only half of the question, not more than that. So today's administrative law, at least I covered how many? I don't know. 23 I covered it seems today. But anyway, that I told you, I'm the Moshi teaching to the people.
They are a little bit lengthy questions, sir. Took more time each question.
It's a lengthy question. It's a lengthy question. So I'm very much thankful to you. Some time
10 more minutes are there, sir. Over, sir. Completed all.
No, because still we are. What did you ask?
10 minutes are there, sir.
Tell me, what did you ask?
Time another 10 minutes may be there, sir. Up
Yes,
to 7.
another 10 minutes are there. But I do have class from 4:30 here. That's why I want to wind up.
Okay, sir.
So the next tomorrow class is professional ethics and cases of the professional misconduct and BCI rules. Tomorrow class. So at least read and come to the class. Let me make the class as a lively class and a participatory class instead of a sermon class or a preaching class. Only one way should not be there. A love should be 2 ways. Are you following me? Say yes.
Yes, sir.
Okay, now I'll stop sharing. Thank you very much for your hearing. Tomorrow we'll be ready because I want to teach to the people here law of tort, defamation. Chapter I would like to teach to them. End of the meeting. Goodbye. Jai Hind.
भारत भाग्य विधाता
पंजाब सिंध गुजरात मराठा
द्राविड़ उत्कल बंगा
विंध्य हिमाचल यमुना गंगा
उच्छल जलधि तरंगा